Four, three, two, one.
This Honorable Court of Appeals of Tennessee is in session.
Thank you, Ms. Dempsey. On behalf of Judge Bennett and Judge Golden, I'm pleased to welcome counsel to this oral argument, which we are broadcasting, live streaming, that is, to fulfill our obligation to maintain open courts. The hearing will be conducted in the same manner as if we were in the courtroom together. Each of you has 15 minutes for your arguments, and the appellant has reserved time for rebuttal. There being no announcements, I'll ask Ms. Dempsey to call the case.
William B. Stinson versus Vest Family Limited Partnership et al.
All right, Mr. Durham, you have the floor.
Thank you, Your Honor. Ryan Durham of the Lawrence County Bar. I, along with my partners Charlie Holt and Wyatt Boston, represent the appellants in this matter before you. And we would request to reserve 5 minutes time for rebuttal.
Certainly.
Thank you, Your Honor. We are here today on the trial court's grant of summary judgment. A grant of summary judgment where there existed numerous disputed facts properly before the court pursuant to Rule 56, and nonetheless, summary judgment was granted. Summary judgment was granted presumably because the trial court constrained to determine the matter before it far more limiting than it actually was. This matter began as a boundary line dispute. Two farms disagreed about where the boundary between them were. Mr. Stinson on the one side, the Vest family on the other. As the court, I'm sure, is well aware from the briefings, there was a large ditch that ran down essentially between these two properties. The disputed area is where the ditch diverges from the surveyed lines. So in that area of dispute is where, and for that reason, the Vest family, in response to the petition for boundary line dispute and a quiet title, raised the defense of adverse possession. The trial court, in its ruling, determined that issues of control and use were not before it. And it did so in part, we submit, because shortly before the hearing on summary judgment, Mr. Stinson's counsel prepared and submitted a non-suit of a slander of title claim. That's all the paper, that's all the document that's submitted did. Non-suit, the slander of title. When you look at the original complaint and the amended petition, there is a one-time reference to slander, but there is in no way a prayer for the court to do anything about that alleged slander. So that matter may not have ever technically been before the court, but that was the only thing non-suited. So by the time summary judgment comes around, what's left before the court? Mr. Stinson's prayer for declaratory judgment, and that prayer for declaratory judgment included two primary requests. And looking specifically from his pleading, specifically to his pleading, Mr. Stinson asked, this is the amended petition, the court to hand down and grant declaratory judgment in favor of petitioner and give the following relief. That the court hand down a decree that resolves all disputed boundaries and clearly declares the true and correct legal boundaries of Mr. Stinson's farm. And second, that the decree memorialize and declare Mr. Stinson's fee, interest in and to such property. So Mr. Stinson, from the outset, asked the court, tell me where my boundaries are, declare where my boundaries are, and declare what rights I have to the fee simple within those boundaries. The problem with that is those rights necessarily incorporate notions of use and control. Another problem with that is when raising the defense of adverse possession, which the Vest family did, use and control are certainly at issue and come into effect. Here, the trial court, based on some conversation between the judge and Mr. Stinson's then counsel, determined that all Mr. Stinson was asking the court to do was to declare where his boundaries were. I submit to you that the record doesn't necessarily support that conclusion. I think actually what the record supports is that when Mr. Griffith was beginning his request to the court and they were having this conversation back and forth about what the non-suit meant and what was left before the court, what Mr. Stinson's counsel, Mr. Griffith at that time said is, Judge, we just want you to take these metes and bounds and we want you to issue a ruling that says the survey is a graphical representation of those metes and bounds. As a matter of fact, he used, you can see in volume 4 of the transcript, page 8, beginning on line 7, he says, just tell us where these metes and bounds lie on the face of the earth. Maybe then, maybe had the trial court done just that, the matter would have been over. Not over, but the issue of summary judgment wouldn't be before the court today, and we would have already proceeded to trial on all the other issues. But the trial court did more than that. The trial court didn't just say, okay, the surveyors say that if you plot out on the face of the earth, these metes and bounds, this is what the lines look like. The trial court went a step further. The trial court said, and those constitute the legal boundaries of Mr. Stinson's farm. By implication, if those boundaries, if what's on Mr. Stinson's side of those boundaries are his, what's on the Vest family side of those boundaries are there. And the disputed area runs right through that. So the trial court even went a step further, I would submit, than Mr. Griffith asked in some modified back and forth in the oral argument on summary judgment. At the end of the day, use and possession always were before the trial court. And the trial court simply erred in saying, no, it wasn't. The trial court acknowledges in its order on summary judgment that there are disputed facts as to use. There are disputed facts as to possession. Those are well raised, but those are immaterial because that's not before us. We submit that simply is error. As a further illustration of the trial court's understanding that issues still remain between these parties, in its grant of summary judgment, which it purported to rule as certify as final, the court said, I know this doesn't resolve all the issues before you, and I'm going to order you to mediate. And if you can't agree on a mediator, come back to me and I'll appoint one. So the matter's over as far as I'm concerned, but you all go mediate. That by itself, clearly in our minds, Your Honor, establishes that there were pending issues. The trial court just erred in saying they weren't properly or they were not before him. They were.
Mr. Durham, the court's order or directive for the parties to mediate, that occurred before the court entered its order of summary judgment. Is that correct?
No, Your Honor, that was at the very end of the very memorandum and order granting summary judgment. It had previously ordered the parties to mediate during the litigation, during the discovery process. But as a part of the trial court's summary judgment ruling, the memorandum and order, which is of record and is also in the appendix that we include for Your Honors, he says, go mediate again. And in that very order, the summary judgment order, he again says, if you can't agree on a mediator, I'll appoint one.
And in that same order, the trial court set the boundary line based upon the two surveys. Is that correct?
Yes, Your Honor, and determined and decided not to consider the issues of use and possession relative to the establishment of that boundary. Those issues are relevant to the boundary, just as they are relevant to the adverse possession.
So the question is, what was left to mediate? And your point is what?
In actually before the court, based on the order that says everything is resolved, nothing. And therein lies the error. I presume, since the judge was saying that use and control and possession are not before me, those are going to be for another day. So y'all go mediate those and argue those at a different day.
Oh, okay. All right. All right. Thank you, Mr. Durham. We'll hear from you on rebuttal. Mr. Smith.
Richard Smith, Davidson County Bar. I represent Mr. Stinson, and I certainly appreciate the opportunity to present his case to the panel. Judge, I believe the order that you were asking counsel about is completely consistent with what the court knew at the time. The court made a decision on the summary judgment based upon the legal document, the deed. But the court was well aware that there were other issues outstanding because of the course of the litigation. The records were replete with these possession arguments, adverse possession, and such as that. I think when the court ordered in the summary judgment order, when the court ordered the parties to go to mediation, he was simply telling the parties, now you've got my order. I know there's other issues out there. Take my order, go to a mediator, and see if those can't be resolved.
But what authority does a trial judge have to order parties to mediate if the judge has resolved all issues before the court?
Judge, I can tell you this, from my standpoint, I usually don't question the court's ability to order anything. And I don't know if the court has the authority to order mediation after he's entered a final order. I don't know.
Is it a final order? Is it a final order if he hasn't ruled on all the issues?
Yes, sir. If a counterclaim hasn't been presented where the counterclaim alleges adverse possession, there's nothing before the court to order. I mean, all of the material facts counsel speaks of all concern possession and adverse possession.
And that wasn't pled? That wasn't pled? Is that what you're saying?
No, sir. There was no counterclaim was ever filed.
But your complaint sought a declaration of the boundary line and to quiet title.
That's right. And then
the quiet title would include issues if a defense of adverse possession is asserted.
No, sir. The defense of adverse possession only applies to situations where the adverse possessor has his rights infringed upon. That's the purpose of the adverse possession. It has absolutely nothing to do with an affirmative claim of adverse possession. And the Vest family had the obligation of filing a compulsory counterclaim and alleging that. And then if they would have done that, none of these issues would exist. That would have been litigated, but the court does not have a counterclaim. The counterclaim was filed 20 days after the final order was entered. I mean, the court also, at the same time of hearing the motion for summary judgment, continued a jury trial that was scheduled for November 9th and 10th. The Vest family had absolutely no intent to file an adverse possession claim. The court asked them about it at the summary judgment, and they said they didn't file it as a matter of legal strategy. So the court had nothing to rule on. There was no claim of adverse possession ever asserted. And it's just as simple as that. Had the claim been asserted, That's what we would have tried. But the court didn't do anything wrong. Mr. Stinson didn't do anything wrong in his pleadings. The clerk didn't do anything wrong. I mean, a counterclaim should have been filed in a timely manner. It was compulsory, and it simply wasn't as a matter of legal strategy. That's why it's not before the court. Does the court have any other questions? I'll be more than happy to.
What about both attorneys saying that neither of them received the final order?
That's true. I believe there was some confusion relating to the matter being heard in Williamson County, and then the court sent the order back to Murray County. But again, the analysis of the trial judge is completely accurate. That's not the duty of the clerk. The duty of the clerk has no duty to send the order to counsel unless counsel requests it.
No, if the clerk says I sent it, then the clerk has assumed a duty, and that's part of Rule 58.
Judge, I thought Rule 58 had the term "when requested." I thought the term.
Well, that's an option after subparagraph 3, but in the subsection 3, it says a judgment is filed when signed by the trial judge and when the clerk certifies that the order has been sent to counsel or the parties. And that's what happened here, didn't it?
Well, no, sir, Judge. No, sir. I don't believe that's what happened here.
Doesn't the certificate on the judgment say, I, the clerk of this court, mailed this order to these attorneys?
Yes, sir, it does.
Okay. Now, normally when we have somebody appealing a final judgment that has already become final, it's only one side fussing that they didn't get their copy. But in this case, all parties, both parties, say, none of us got it.
All right, and that may very well be true, Judge, and I agree. But what would be the difference had it been sent?
Well, the clerk said it was sent.
I know, and had the clerk done it, what prejudice has been created? Because I don't think there has been any, because a counterclaim was never filed.
No, isn't there a prejudice as to the timeliness of the appeal?
I don't think that's an issue, Judge. I don't think the
Was the notice of appeal filed within 30 days of the entry of the final judgment?
I believe that. I'm not sure. I'm not sure about that, Judge, but I don't think whether this matter is ripe for hearing is an issue. I mean, I'm not sure that we've been prejudiced, because here we are. I mean, we're
Isn't Mr. Durham claiming that the Vest family has been prejudiced because they didn't receive the notice of the entry of the order until after 30 days?
Yes, sir, they are. But that has absolutely nothing to do with the fact that they filed a counterclaim 20 days after the final order had been entered.
I'm not talking about the counterclaim.
Yes, well, what prejudice? What could be the prejudice to the party? That's my point. I mean, if the counterclaim was never filed, it was never filed. If the appeal's timely, and it is because we're arguing it, then I just don't see what the prejudice is. I mean, what rights have they been denied? I mean, a counterclaim's not filed, a counterclaim's not filed. It was never intended to be filed. None of this is before the appeals court. I don't think, and I don't think if the order would have been sent.
Well, what do you think is before this court? You've ruled out a lot of stuff. What do you think is before this court?
Whether the summary judgment, whether the granting of the summary judgment was appropriate.
Okay.
And I believe it was. I believe it was based on 2 surveys and all the law that council cites, which may give other options to a judge are simply moot because the surveys agreed as in all material respects. And so I think the summary judgment was proper. And I just, I think the failure or the mistake was the failure to file the counterclaim. If a counterclaim would have been filed, all of these
So
issues.
is the Rule 60 motion before us on appeal?
Yes, sir.
Okay, you didn't mention that.
Well,
I asked you what was before this court.
Well, Judge, I did too. I mean, I'll be more than happy.
And why did the court deny the Rule 60 motion?
The court denied the Rule 60 motion because there was no accounting or clerical error in the content of the summary judgment order. I mean, most of the Rule 60 that I've ever encountered in the cases we reviewed are simply a mathematical error.
Wasn't a big issue in the Rule 60 motion that we never received a copy of the order until more than 30 days had expired?
Yeah, well, it's my
You addressed that.
Sorry?
You addressed that in your response to the Rule 60 motion.
Yes, sir. But I was under the opinion that counsel was attempting to change the content of the order. and that the 30 days has absolutely nothing to do with the content of the order. Counsel hasn't requested, a change of the content of the order. So I don't see any prejudice one way or the other. If he would have gotten it, what would be the difference? What would we be here arguing that would be different?
Anything further, Mr. Smith?
No,
I'm not cutting you off. I'm just.
No, sir. I will be more than happy to address any questions, but that's essentially all I have to say.
Does the panel have any questions of Mr. Smith?
No.
Hearing none, Mr. Durham, can you address my concerns about the Rule 60 motion?
Yes, Your Honor. We raised the Rule 60 motion because obviously we had received the copy of the order well after the normal appeal time had run. Both counsel did. And the way that timing worked pragmatically, Your Honor, was counsel's right. Mr. Smith is right in that there had been no counterclaim filed at that point. There had been none needed because adverse possession was raised as an affirmative defense in the answer. That was well before the court. The statutory sections were provided. It was there ready for the court to rule on because at that point, all Mr. Stinson had done is ask the court to draw a line and name a boundary. He had not actually encroached upon the Vest family farm. It was after summary judgment or after the arguments on summary judgment that Mr. Stinson then encroached upon the disputed area and started putting up posts and signs. That's when the counterclaim was filed because that was his first time of actually stepping on the property trying to take it away. Otherwise, it had been just a legal action of help us determine that this is the boundary, and we had raised the proper defense. No, you can't do that because the statute of limitations says it's ours by adverse, it's the Vest family's by adverse possession. So that gets filed right before Thanksgiving. Shortly after Thanksgiving, it comes to everybody's knowledge on December 9 that the order on summary judgment had been filed. So here we're looking at an order that purports to resolve the entire case that we don't get, neither counsel gets until the appeal time is run. So our motion was to ask the court to do one of two things, essentially. Certified as being sent or valid on December 9 so that the appeal time starts to run then, make that change to it, or remove the reference to certification as final whatsoever so that it just remains interlocutory, giving us the right to appeal. So yes, very much that was before. Now, if Mr. Smith doesn't wish to challenge the timing of appeal based on the notice being filed after the 30 days ran. We're good with that. We think we're properly before the court because we have filed within 30 days of the court ruling on our Rule 60 and Rule 58 and 9 motions. But they are before the court. I think that
if, and I say if, the only issue properly before the court is the trial judge's ruling denying your Rule 60 motion, what is the practical relief if we say the parties did not get, neither party got the order, and therefore the Rule 60 relief should be granted, which means the final judgment would be entered at a later date. But then you've still got the same issue about whether there were other claims before the trial court.
That's right, Your Honor. That ruling by itself does not, in that scenario, resolve the appeal. All that does is say, I believe, Your Honor, is that our appeal is timely. Our appeal of the motion for summary judgment was timely.
Mm-hmm. Okay. All right. And your ultimate claim is there was at least one other issue before the trial court, and the trial court has not ruled on that.
The issue of adverse possession was before the court from answer number 1, and it
All right, I'm afraid some counsel has frozen in the cyber technology, so let's pause for a moment. Mr. Durham, I think you have lost your connectivity. All right, we have lost Mr. Durham. Why don't we pause for a moment to see if he can reconnect before we conclude this argument. Mr. Jacobson, can you advise if Mr. Durham is trying to reconnect with us?
It does not look like it yet. I am waiting to see if he does try.
All right, we'll wait one more minute.
Somebody need to call him.
I think Mr. Jacobson's going to reach out to him.
I unfortunately do not have his number, but if Miss Dempsey does, that would probably be the best. Or Mr. Smith, if you have his number, if you're able to call him.
I have his number. I'll try to call him.
Okay, thank you, Angie. Okay, he is rejoining now.
Good. All right, Mr. Durham, we paused when you froze. Can you hear me now?
Yes, Your Honor.
All right, you had about 35, 40 seconds left, and we were talking about what relief is available to you, and we were talking about what claims you believe were still before the court.
Thank you, Your Honor. And I apologize about falling off there. We believe and submit that adverse possession was always before the court. Use, control, and possession always was before the court, not just to the issues of adverse possession, but also to the issues of establishing the boundary itself, the legal boundary above and beyond, as might be different from that drawn by the survey. All the issues of a standard boundary line dispute where adverse possession is at play and where summary judgment is usually not granted because of disputed fact were before the court. And for those reasons, we submit that this court should reverse the order on summary judgment and Rule 60.
All right. Thank you, Mr. Durham and Mr. Smith, for your arguments, and we will take this matter under advisement. Ms. Dempsey. You're muted, Ms. Dempsey.
This honorable court is in recess until 1:45 p.m.
Thank you, Ms. Dempsey, and thank you, counsel. You are free to exit the meeting.